argument in the course of the day. I'll come up with report.
Okay.
Okay.
If I am preparing for a phone number for value account for file
to file affidavit in opposition. Have you taken consent? Inform them. Yes. Okay, give a date as per your okay. The matter stands adjourned on the prayer of the learned counsel for the respondent to file affidavit in opposition. As the petitioner has expressed urgency, list this matter on
next Friday.
next Friday.
For adjournment of item number 18 and 27 for today and said there's some
Item number
18 and 27.
okay. 18 and 27. 27 there is an adjournment slip, I think. Okay, adjourn. And we listed next week.
Item 10 matter. I'm saying estimate for the day. Okay.
Why?
I have to leave myself.
Item number
10.
10. On the prayer of the learned counsel for the matter, with the petitioner, the matter stands adjourned and be listed after 2 weeks. After a week. Seven, 7, 8 is by order. Seven, 8, and 9. Adjourned. 7, 8, and 19. 7, 8, and 19.
Math please. That's my prayer for listing the bill. That's what Monday. One Tuesday, the petition exam will be.
Go to the criminal bench.
But in this, it was for more than 7 years. From 11/9 to 15/9.
Still that is there in the list.
This for Monday, not for
Today is civil bench 2. Okay, number. What is in your case? When died? 2000. Apply 2003. All matters are adjourned. All those matters are adjourned today. Are you aware of these 3 new recent judgment? Honorable by Honorable the Chief Justice of India, one by my Lord Justice M.R. Shah, and then he was, and other is by Her Ladyship Nagaratna. Aware? All these judgments, all adjourned matters. Okay. We'll handle it when we are in a regular bench. There is a stopgap arrangement. Adjourned. Yes. 54. Huh? 54. Okay, no problem. We'll take. Otherwise, we'll lose. Yeah. Twenty. Appointed in the year 2012 on compassionate ground. Now you have acquired qualification. So you have one appointment. There is a limit to everything. Adjourned. 30. Okay. Adjourned. Keep Tell us a date. First week of October. 4th of October. As agreed to by the learning council by the parties, matter stands adjourned and be listed on 4th of October.
Saying adjournment item 9.
11/2/2012. Right. 2004 applied. 2023 approached this code. Okay, adjourn. Adjourn for 2 weeks. Huh?
For admission.
Make a mention to Monday in the regular bench. The dead bench might have some planning as we do unnecessarily. Make a mention as per.
Item number 20. On Monday.
Why?
Council is out of state.
21 and 22 both. Isn't it? Huh?
No, I don't know, 20,
20?
20.
Okay. This was a good case. Yes. On the prayer of the learning council for the petitioner, matter adjourned, stands adjourned for 2 weeks. Twenty? Like 2006.
Next week,
26. Adjourned for a week on the prayer of the learning council for the petitioner. All compassionate gone. All adjourned. At motion stage itself. I was thinking of passing a common judgment. Lawyers are very smart. No, they knows the law. Yes.
motion A B, item number 1.
Second time only.
Okay, CDK, call for the case diary. Okay, ask her PP a date and give her date immediately. Yes, you have a talk with the public prosecutor and we'll fix a date before puja.
Maybe this so that we can inform.
I'll have to take, so if October 11th is a holiday.
For motion, item number 2.
Just inform the people. Yes. Better you take adjournment. Thank you.
Item number 2, 3, and 5.
2, 3, and 5. Why these matters are in motion for so long? Pleadings are complete. Will issue notice fixing the admission. What remains? These are in motion for long. The pleadings are complete. Yes.
Item number 4.
Yes, Deputy Commissioner was to show cause. Okay. The Learned Standing Council for the Education Government, the Learned Government Council submits that the instruction in terms of order dated 30/8/2023 has been received and affidavit shall be filed within a period of a week. Accordingly, he placed for an adjournment. Prayer is allowed, list after a week. And affidavit be filed in terms of order dated 30/8/2023 before the next date fixed. Give a date,
26th of September.
25th of September.
Item number 6.
Third, you are Mr. J. Laskar. Learned Council for the petitioner also heard Mr. Bora for respondent number. No, let us do one thing. Heard Mr. Swenso. This is an application assailing an order dated 10/4/2023 passed by the appellate authority constituted under Assam Education within bracket provincialization of teachers and reorganization of educational institutions within bracket close comma Act 2007. 2007. Issue notice returnable on after 6 weeks.
19th of October.
Returnable on give after
7th of October.
7th of November 2023. Mr. Bora hold on. Issue notice. Mr. Bora accepts notice on behalf of 1, 2, 4, and 6, and you respondent number 5. Petitioner to take steps. Who is to be 6? You are also 6. Bora 6. As the parties are duly represented, no formal notice need be issued. However, extra copies be furnished to the Learned Council within a period of 5 days from today. The respondent number. Who has passed this order? Respondent number 2. That is also you are not aware. Who passed this impugn order? Respondent number 2 shall the Learned Council for the respondent number 2 shall keep the record of the appeal preferred by the petitioner in which the impugn order has been passed be kept ready. So, or shall keep ready for perusal of this court. Yes.
Item 11.
Yes, who represents KV? Yes, yes, tell us.
In this case, we have already complied on 13/9, we have one order. Approved the transfer from Maligaon to Bora.
Okay, give us.
Building hours, next thing has completed the
Yes.
It is not regard has been starting.
That has been done. Kiran, Koran, Kirat, Kaishap is permitted to get admitted in Jorhat.
It is not intimated idea.
No, nowadays it intimated. That's fine. So can you close this petition on the basis of this?
Yes, admission is recommended.
Recommended so that will be done.
Apply to, right?
So we'll close it.
Yes.
Keeping this on record, first of- the present petition was filed by the guardian of, isn't it? Mona Lisa Hazarika is the mother of one child, namely Karan Kirat Kaishap, is filed for Karan Kirat Kaishap. Full stop. The grievance of the petitioner is that the authorities of Kendriya Vidyalaya are not permitting her ward to be admitted at Jorhat Kendriya Vidyalaya on
AFS number 1.
AFS number 1 from the Kendriya Vidyalaya Maligaon. NFR Kendriya Vidyalaya, NFR Maligaon. NFR Maligaon. The basic ground is that the petitioner, the ward of the petitioner has not been able to adjust at the present school, that is KV NFR Maligaon, in as much as the father of the petitioner is a differently able person, and they are having some financial difficulties also. Full stop. Accordingly, as their grievances were not redressed, the present application was filed. At the time of hearing, the learned counsel, Mr. E. Das, representing the Assistant Commissioner, Kendriya Vidyalaya Sangathan, submitted a communication dated 13/9/2023, whereby it is produce a communication date so wherein whereby the competent authority under Kendriya Vidyalaya Sangathan has allowed the admission of the ward of the petitioner, namely Karan Kirat Kaishap, at KVAFS Jorhat for the session on the basis of Kendriya Vidyalaya Transfer Certificate Rules Part 7. In view of the aforesaid, nothing survives in this present writ petition. Accordingly, same stands closed. This court expects that the competent authority is KVAF Jorhat shall forthwith comply with the such order of the competent authority dated 13/9/2023. Full stop. The communication dated 13/9/2023 is made a part of record and marked as document X. Give a copy to him. Are you having?
I figure that
Okay.
Number 12.
हाँ. Is it after something? We will also go there. No. About the. Is a what does inform us? Not 10:30, but whether. Okay.
Item number 13.
Yes. Will issue a notice. Okay. Yes, what do you say? Heard Mr. S. Borthakur, learned counsel for the petitioner. Also heard Mr. G. Pegu for the standing counsel for the elementary education department, and Mr. Swanshu for 4 and 1. The present writ petition is filed under Article 226 of the Constitution of India, raising a grievance that in terms of the Government of Assam notification dated 21/7/2023, the It's 2023 Silo Goyate. People.
There's an increasing high understanding is considering the raising the given that the in terms of the government of Assam notification that it will be.
True. The one Rahmat Prathamik Vidyalaya Monakosa Borpeta is proposed to be amalgamated with number 276 Monakosa LP School under lower primary school under the Shiksha Khetra scheme. The basic grievance is of the petitioner is that the said Monakosa lower primary school is having no land in its name, and the school lacks sufficient infrastructure, toilet and playground, etc. Whereas the present school, that is Rahmat Prathamik Vidyalaya, has all the facilities mentioned above. It is the further case of the petitioner that if the amalgamation is allowed, the amalgamations that merger is allowed, the distance of neighborhood the peoples will be 2.5 kilometers, which will be in derogation of the section 6 within bracket 1 within bracket A of the right of children to free and compulsory education rules 2010. Mr. Borthakur, however, submits that the petitioners have already filed a representation before the authority, and in the meantime, the government of Assam in the school education department has issued a notification being number E225754/1 dated 10/9/2022, whereby a committee has been constituted for consideration of the grievances of such disputes regarding amalgamation, merger, and a process of re-verification, and the said committee has been authorized to determine the re-verification, and the committee has been named as amalgamation / merger re-verification committee. Accordingly, Mr. Borthakur submits that as already a committee has been constituted by the government, if the present writ petition is disposed of, directing the aforesaid committee also to consider the representation filed by the petitioner, the petitioner shall have no grievance to be raised in the present application. Subject to, however, the final decision of the said committee. The learned standing counsel, Mr. Pegu, submits that he will have no objection if the petition is disposed of by relegating the entire matter to the committee constituted by the government within brackets to the committee constituted within brackets supra by the government. In view of the aforesaid consensus, the present writ petition is disposed of, allowing the present writ petitioner to approach the committee constituted under order dated 10/9/2022 within brackets supra within a period of. You can file a phrase if you can file a phrase within a period of 7 days, and on being approached, the committee shall consider the same within a period of within a period of 4 weeks thereafter. 4 weeks thereafter, and consider the grievances raised by the petitioner. Since consideration is just considering that matter is unmet, that the government itself has constituted a committee for verification, and that matter the petitioner has already approached the said committee. In the interest of justice, it is provided that till the committee takes a decision within the aforesaid period, the present status of the school, both the school shall be maintained. I say. There is a committee, go there. Where is that last order, last copy?
My lord, I have filed a appeal
Mm.
for item.
You prefer there, they have looking in,
We have taken it.
we have challenged that. Okay, let the senior come.
Item 16.
Yes.
The petitioner
Mm.
having a brilliant academic career.
Mm.
One.
No, academic career will come later on. We presume that you are having a brilliant academic career because you have been called for the interview. Okay? We presume that you are having a brilliant academic career. Now tell us what is your grievance.
I don't.
Uh,
I
uh.
also
Okay, we know that.
Yes.
Your PhD in foreign language. In Bengali, okay. Okay, I am confused with Mr. Chaudhury's case.
Advertisement for appointment to the post of assistant professor in Bengaluru.
Yes.
In the others from
Mm.
Shahinga.
Mm.
And the disability certificate will not be filed in excess.
Page
Election 6, page medal 140.
140.
Yes. And the post is reserved for permanently disabled person.
Where is that advertisement?
Advertisement your lordship, prior to that your lordship kindly see me out. Annexure 7, page 141.
What is that?
Guideline, office monument.
Do not come to that guideline. Your case is
How marking paper.
no. Where is the advertisement? Tell us.
Advertisement is at page 145 annexure
1.
advertisement is 27, 28.
So up to 145, all the record of brilliance. Up to 139, all the records of brilliance. Okay.
I scored the highest mark.
Okay. Where is the advertisement? 145.
Page 145 annexure
145 annexure A. This your subject is
A.
Bengali.
Serial number 6, assistant professor Bengali.
PWD.
PWD1 in Skillor.
Mm.
Person with disability.
Okay.
This is reserved for person with disability.
Where is the comparative statement of marks?
Hello?
Where is the comparative statement of marks?
That is with the interview of committee. That is
Who has been selected?
that is because nothing has been disclosed despite our decision. That's why I am before your lordship, my lord.
Okay.
My candidature has been, my lord, rejected. My lord, your lordship kindly see, my lord, the paragraph 12 and 13, my lord.
No, we'll come to that.
My lord,
Now tell me, you participated in the
in the interview.
interview,
And in the
then
interview,
who was selected?
my lord, I don't know who has been selected by, but my lord, by putting some questions which are absolutely irrelevant, my lord, my candidature has been.
Where is that?
That particular order, by that particular decision,
According to you, you presume that your candidature has been rejected
rejected, because your lordship can see paragraph 12 and 13.
of your pleadings.
By
That you say that you have been asked some irrelevant question.
the question your lordship, shocking, they asked me, one of the members,
This petition is premature.
your lordship kindly consider, they will appoint somebody else who is not resulting,
Whom they have selected?
somebody is, there are 4 candidates.
You are representing whom? See, even if they have committed illegality, that will go to the Director of Higher Education. Director of Higher Education is not a rubber stamp. It will have to apply its mind. File a representation, including paragraph 12 and 13, that these are irrelevant questions asked. See, this repetition is in the air. There is no order rejecting your candidature. There is nothing.
But that gesture and posture, my lord, looks like, you know, that. my-
Their gesture and postures can a writ court issue a writ of mandamus or certiorari on the basis of gestures and postures.
You kindly consider whether they put a question. Which is absolutely shocking, whether they say.
You have-
ask,
You
know,
have two options.
What money you have paid for obtaining whether PhD degree?
Who knows? Have you made that interview, person taking interview a party?
Make them party, whether they person, whether they-
That person
Why not?
will issue notice there. Nothing more. Two options for you. Either a dismissal on the ground that this is a premature petition. Nothing is there on record. Or you file a representation before the Director of Higher Education. Something should be there. Only on gesture and posture can we pass any order.
Lordship can be considered. If, my lord, I am, my lord, deserving candidate.
According to you, you are the deserving candidate. We do not know.
My lord, your lordship may call for the record. For your lordship satisfaction, my lord.
We'll call for the record, even will stay. Moment if you are a desirable candidate and you are deprived, not only motion, will stay that. But on what? On the paragraph 12 and 13, where you say that I have been asked certain irrelevant question and their gestures and postures are not favorable to you. It seems that they will favor somebody else. Can that be a ground for repetition?
Absolutely, my lord, your lordship.
So can a repeat is maintainable on apprehension? Who knows that you have already been selected?
Somebody is selected, my lord, declaring my district.
Come there, come then.
Then, my lord, everything will be infrastructure, my lord, then they will pay the payment and then.
Why it will be infructuous? He will get appointment, we will throw him out. We have thrown people out after 15 years. For this illegal event, after 15 years. No observation. No observations on the basis of what you use the word, gestures and postures. Observations on the materials available, not on gestures and postures. No.
There are certain delegations, your lordship will, the respondent number 7 in that, my lord, I have been intimidated like this.
There are some provisions for your protection. You have some protection, go there and file application.
Yes, your lordship is absolutely.
There are provisions, special provision under Disabilities Act, if you are humiliated. But this is not the, writ court cannot issue a notice on the basis of gestures and postures without anything. We only on apprehension that since this question has been asked, my candidature is rejected.
Kindly appreciate whether it is a reasonable question of that how much money I have.
Can we decide all this?
Can
Can you decide this, all this, what question? They may ask your capability of asking some absurd question. How you react? Because your student may ask anything to you as a teacher. How will you react in that situation? That may be their test. If petition stands dismissed, being premature. The present writ petition stands adjourned on the prayer of the Learned Council for the petitioner list next week. Best order you can get. If you still insist, then the other order you can pass right now. 3 minutes it will take. Which option?
Because my wife.
Somewhere else, yes.
Ending 15 to exit.
Motion, no?
Let me file a representation before the authority to consider my case.
Highly, we have,
I have.
highly, we have adjourned this matter, adjourn it. Yes, next. That option was given you at the earliest. Yes, next case.
Pending item 15.
Yes, yes.
Order.
Where is the appellate order?
Election 11, page 81, 81. Yes. After coming here, we have a order. The order time is not appropriate for the action. We have a position of our board, our board pass an order to go for a election. We have accordingly opposed. That this order is, possible wrong, given by us. Not been taken into consideration at all. What they can be done. And these are, I feel, this and in Malaysian order maybe still come to this.
What is your problem?
Problem is this school, basic school is just by the side of the area of the support campus. As per office memorandum,
Hmm.
this is the violation of that. Therefore, main point is here, my lord, that particular basic school is to be our school be amalgamated. Definitely prior to 23 of 2023, 6/4/2023 itself because we converted to others Vidyalaya because all regular documents.
This is a model school. You will be in a you will be in a better position to be with the model school.
Their school has already been in for Abdul constituency for a 126 school to Rossio. That for Abdul constituency, this school is adopted. This already been converted to other schools. Then it is where CBC school has been started also. This school, no more this basic school is known as the Namti Boys Higher Secondary School.
See, it's an administrative decision
That is the Emilor.
saying that there is no distance, distance is zero between school A and school B. Just let, what I have understood, school A and school B, there is zero distance.
Yes.
Okay, no dispute on that.
Yes, yes.
Now, school A is under the scheme of the government whatsoever has been declared to be a model school
Model.
under a constituency. So it will be developed as a model school.
Yes.
Now, nearby that school, there is another school. So that is sought to be amalgamated with the model school so that all are benefited. Can we interfere in exercise of our jurisdiction,
Yes.
all these issues?
Yes, it is fine.
So that is why we are issuing a notice.
Maybe, that's why, because
We are issuing a notice, we'll examine it. Our power to interfere with this kind of administrative work.
right, that's not, see, I don't know, nothing, but still there, consideration is done, not being state. It needs to be marketed. And what is our record? Because our.
We'll separate your school.
Chief has pointed out, we are agreeing with to go with the model school.
Yes.
But our school is still not counted as a model school. Our school is being amalgamated as
Huh.
higher secondary school.
Huh.
This school is basic school is not there, my lord. That is our point. That is our.
According to you, that school cannot be a base school because it has already been changed its character. It's good that you are being part of a model school.
Coming with instructions. Okay, we will be also same model school. That is something else, but as on date, we are being converted to higher secondary school. That is why I pay for the short date, maybe keep on not MA5, or structural not issue, related to a protected mirror, otherwise the is our mirror.
Sorry, no interim order. No interim order in this case. Heard Mr. Borwal and counsel for the petitioner. The present writ petitioner is preferred by School Management and Development Committee of Namti Girls High School, Namti Girls High School, being aggrieved by an order dated
20.
order dated 13/8/2023 passed by the committee constituted by the government of Assam in school education department to consider and re-verify the amalgamation merger of schools. Full stop. The case of the petitioner is that the Namti Girls High School is sought to be amalgamated with which school? Namti Boys HS, Namti
Boy, higher, secondary.
Namti Boys Higher Secondary School. However, Namti Boys Higher Secondary School, in view of conversion into a model school, is not even existence. Therefore, such conversion itself is illegal. Itself is illegal. Considered the submission of the Mr. Borua. Accordingly, issue notice returnable on dividend after 6 weeks dividend. Quick. You cannot take 13th of October 2023.
And up your lot is 12 my son's village there.
Okay.
It's right.
Okay.
Maybe after 15, 16 or 17.
No, 15, 16 November after Diwali,
October also.
15,
15, 16,
16th of October 2023.
I should come to you first.
2023. Full stop. In the meantime, in the meantime, the respondents shall file their affidavit. Respondents shall file their affidavit regarding the status of Namti Boys Higher Secondary School. Issue notice on interim prayer also. The same shall be considered on 15th. 15 is a holiday. No, holiday start from 20. You will have to remove that calendar. Holidays will start from 28.
All right.
প্রথম না আগে এই গানে লাগে আগে প্রথম না কোনটা রিপ্রেজেন্ট করেছে প্রথম এই গান লাগে ইস্যু নোটিস করে আগে
Okay. Your Mr. U. Sharma accepts notice on behalf of secondary education. You are for 4 and 5. So, status. As all are represented.
The case of school is
Okay.
You
You can appear. Education department can appear. One also. Principal is a government, and he is having no role. Role is also of the committee. Okay. As for no all action, no formality. Step.
We are also lucky. Because
Okay.
others will be in dilemma.
Yes.
Malay Board of Secondary Education Department has the board of principal.
Why? Because principal is your employee and he is not having any role. Principal is your employee. What will he say? If you can appear for director, why not principal? He is not as an individual by name. He is a principal.
Right.
You take steps, extra copies within 5 days.
Standing attempt 2.
Yes. When your father died, when you applied,
He applied on 10.
and then what happened thereafter? Nothing happened. And what is the year? What is this year? Then nothing to be looked into. You have approached this court very late. And compassionate appointment cannot be a mode of appointment. This is done at the time when the family is in distress. If you can survive from 2011, nothing can be granted. Huh? There are three judgments. I'm just right now quoting and will dismiss it. One by my lord, the Chief Justice, recent judgment will not go to earlier, D.Y. Chandrasur. Then other is my lord Justice M.R. Shah, and recent by my ladyship Nagaratna. All are in the computer. I can, principle is laid down. I can dictate it right now. We want to see the principle is in a paragraph, 10 principle given, one, not a single is applicable in this. And above that, unreasonable delay. Since it's a stopgap, that is what I'm saying. These are not the cases. Okay, Argo. Argo the case. Let us have a judgment for the education department. Yes. That is the on the prayer of the learned counsel for the petitioner list this matter after go through the judgment. But these are, I do not think these are reported, very recent judgment. All others are adjourned at 10:30. Very smart lawyers. Sir. Yes. All compassionate appointment 2003, 2005, all adjourned at the motion stage. So that's why, yes. Okay, adjourned. Which item? One. Okay. Yes.
One.
Item number 2, 3, and 5.
2, 3, and 5.
2, 3, and 5.
Adjourned. Okay.
List of that. List of that.
List after a week.
Item number 12, standing matter.
So your PhD degree in foreign languages, they have not considered and not given mark.
Very few. Because according to her, she academically is the best. Compared to her friend, since you are not selected, then she get representation and RTI application, asking the reason why they are not selected and marking pattern. They find it to the college says it go to the director of higher education, director of higher education says it goes to college. Then college again says that the records have already been handed to the higher education. Now, in view of her complaint,
The other person, the person selected has joined in the meantime.
they have not, if they want it, kindly comes to, is 65. Sorry. Page 62. They started the document started with 59. 59 is the document, it's for pending appointment. Page 59.
So who will produce the record, that cooperative statement?
Director of higher education.
Have it, we'll see it if she properly marked given, she is below. Will this, she herself will withdraw or will dismiss it?
Yes, and in the event they have rejected only because I have got my PhD
The in foreign language, that may be there may be a debatable,
Then I'll satisfy worship.
then there will be requirement of a debate.
Yes. One of the worship can you come to page 62?
Now what will you do?
My submission of the appointed director is to take a call, or he has to take a call. And the director is the appointing authority. So, earlier, I have also faced the use of
So understand, here is a judgment which says the director cannot be the rubber stamp.
Yes,
he will apply his own mind. So let you propose that let her file a representation saying all her grievances. He take a call, but till then,
Till then, no appointment will be.
if that I think you should be happy. Let them give a reason that this is the PhD. Then you come back to us immediately. See, one problem is this here. Generally, staying a appointment of a teacher in a school, college or school is difficult because students suffers.
No, they have stayed it. That's why I'm insisting that you also will see basic.
Page 62.
Yeah. Serial number 40. This is the list of the colleges that have been where the appointments are pending.
Okay.
Now.
Page 62. Yes. SB Devra.
SB Devra College, Kamru, Sudipto Kupon has been selected.
So you are Dr. Kakolida.
I am Dr. Kapil.
So on your complaint, it is sent for verification.
So they have not taken any decision, that's why.
So then it will be your premature, repetition will be premature.
No, it
Why are you thinking that they will go against you?
cannot be, because I have filed RDA application asking for the marks.
Because of your conduct, you have a, what is the status of verification? Have that instruction, that's all. Huh? Okay. Heard Mr. M.K. Chaudhary, Learned Counsel for the petitioner. The present petitioner participated in a selection process for the post of assistant senior counsel assisted by Mr. Bharat Das. In selection process for the post of assistant professor in the Department of English, SB Devra College, Ulubari, Guwahati. The apprehending that petitioner has not that the candidature of the petitioner shall be rejected primarily on the ground that she has obtained her PhD degree in foreign language.
From the Department of English, from the Department of Policy.
In English, however, from the Department of Foreign Language, Foreign Language, Guwahati University. Accordingly, she has filed a complaint before the DH, Director of Secondary Education, Director of Secondary Education, Higher Education, and in view of such complaint, the appointment to the post has not been made. Full stop. Taking to the annex, page 62, within bracket annexer 5, Mr. Chaudhary submits that the reason for not proceeding with the selection is given in the aforesaid document, that for the reason of the complaint filed by the present petitioner, matter has been sent for verification. However, even after his application under RTI before the Director of Secondary Education as well as Higher Education, as well as before the governing body of the college, has not been responded. Full stop. Accordingly, having no alternative, the petitioner has approached this court. Mr. S. Das, Learned Standing Counsel for the Higher Education Department, submits that as the page 60 itself reflects, the matter is pending for consideration. This present repetition is premature. However, he submits that he can obtain instruction regarding the present status of the complaint filed by the petitioner and the action that has been taken by the Director of Higher Education in this regard. Full stop. In view of aforesaid submission, the matter is adjourned and be listed on. Give a date.
Will be after 24.
27th. In the Muson column again, on the said date, the Learned Standing Council shall apprise this court regarding the status of the decision to the selection of the post of assistant professor in SB Devra College, including the status of the complaint raised by the present petitioner. Till the next date, as no appointment order has been issued and matter is under consideration, no appointment orders have been issued. Mr. Okay, Mr. is present representing the UGC. You have it. It may become impact, so you may say, no, we have selected her.
Yes. That is-
That-
they have not been able to decide,
Yes.
because I am reading English, so the department is foreign. And foreign.
English is a foreign language.
Plain understanding. Okay.
Item number 17.
You are appointed as second
OBB.
Yes, sir.
Let me not take up the OBB methods. Huh? Because there is a special bench regarding all this OBB pension and all. Division bench relating to the judgment passed by Brother Borua.
So, Lordship, there is a employee, Lordship, penalty case for.
But you want pension,
Now, pension
but-
as a penny selector.
pension, but in OBB judgment pension has been refused.
Lordship, penny selector.
No, that we understand, but the moment OBB pension is there, I should not take up. Because I'm sitting in a special division bench, taking up the challenge to just the Brother Borua's judgment. Okay, so
Next one.
I'll list this matter next week.
Yes, yes.
No, no, this is- no, no.
Item
Otherwise,
20
we are not sitting tomorrow, next week. Yes.
Item 21.
Yes, yes. Why don't you do the verification if he's, yeah, in, he's in, if he's out, he's out. Classes have started.
And moreover, your lordship, there is a state level.
My lord, that is what I am telling, my lord, he has to implement that one.
Yes, that's why implemented.
That is not implemented.
Implemented.
You are still in 2020.
No, respondent three, state level.
Exactly, that is what I'm trying to convey. My lord, what happened in 2022, 8 June, WPTBC department has been bifurcated.
Hmm.
And now, as of today, after this notification, my lord, this OBC, MOC and SC, these three parts have gone to social justice and empowerment, this department. So they have to be included as a party here.
You understand? See,
And
this
that
is
scrutiny
a,
committee is also, my lord, it's a new scrutiny committee under social justice.
okay,
So
okay.
let
Let us forget everything for a time being.
My-
Who is to do?
my lord,
So there are some authority.
my lord.
Your stand is that authority is doing.
No, my lord. Authority is not doing. Authority, if we go by Madhuripati judgment, my lord.
Yes.
Authority is only empowered when it is referred to the authority.
Now, what is his grievance? He says that you have sent it for verification, you. So give the result, whether he is a OBC or MOBC, whether he is entitled for the series. This is your case.
Yes, sir. And my-
According to him, he was brought to, he was called to the counseling. He participated in counseling, selected, but somebody files a complaint that he is not. So accordingly, the authority has decided we will verify it. Verify it. Already classes are started.
My lord, verify, but whether it was referred to the committee, that is no question, my lord.
That is question you will have to
No,
ask
my lord.
yourself.
I am the authority.
So I will ask that since you have not verified, admit him,
No,
sub provisional admission.
my lord, this is sent to me, whether it was sent to me.
Who will send?
The court will send, my lord.
No, court will not send. See, he was asked for participation in the selection, in the counseling.
My lord, they have,
You are representing whom?
I am the scrutiny committee.
No, who is medical education, who is representing medical education?
Their name is not from the cause, they have not given a copy to them.
No, copy has been given.
Just now, health has informed me.
call health or other as well, saying that if you are sitting over, give him provisional admission.
Yes, that could also be stand of this all of us for the university in Madrid. Let you, whatever be the outcome.
Why don't you decide if he's entitled? Why are you putting the blame? He claims to be OBC or SC, ST. You call him on the basis of such claim. He participates in the selection. If somebody files a complaint and he is not, might have a fake certificate. That is not our concern. Our concern is you call on the basis of his certificate. He has participated. Somebody files a complaint. Can you allow him to wait for your inaction? We are on your inaction. If his certificate is fake, throw him out. Then we'll hear his repetition later on.
There's a medical has to.
That's why. Where is medical education? Name shown? Huh? Well, say we are waiting for some time. Otherwise, we'll ask to give him provisional admission.
No, you lost it. Another difficulty is there, you lost it.
What is fixed on to 18? No. What is this issue? What is this issue? Tell us.
Regarding the issuance of caste certificate of ST card and T card.
Those are not selected. Those are not selected, you lost it.
No, someone selected.
No. Let us understand. Let us understand. There cannot be any common thing to all this. Individual cases are different. I am having my certificate. While at the time of counseling, I uploaded a certificate. So I come into a category. All these are online now.
Verified.
He verified or not verified, forget about that. He was called for counseling under a specific category. In terms of his mark and position in All India ranking, he is entitled for, and state ranking, he is entitled for admission in a medical college on the basis of his certificate. Somebody says, no, his certificate is fake. Okay. So you believe that, or you want to have a verification that may be fake. It is whose responsibility to make it verification forthwith and give a result.
Scrutiny committee will do ballot, but there is a laid down law. There is a procedure ballot for that. It has to be ballot. There has to be.
So follow the procedure. Who have asked not to follow?
But that is to come unless it is referred to the committee. Committee will take so much.
Who will refer? This is you who are doubting his certificate.
No, my lord. Scrutiny committee never doubts anybody's certificate.
No,
Scrutiny
you are
committee.
scrutiny committee.
Yeah.
You take that side. We have no business with you.
Let them scrutinize your.
Your role has not yet started. You take your seat. Who are you?
Depending on the department, and for the feedback filter.
Call health, or otherwise we are asking him to give a provisional admission. A provisional admission subject to outcome, and we'll issue rule. We'll return and issue rule, and we'll fix it the hearing in due course. We have no business now. Why should he go to the Madhuri Patil committee? It is the health, they will have to do it. Because health believe his certificate. Some Tom, Dick and Harry has filed an application that no, he is not scheduled caste. Okay, he might have have done some mischief. His certificate is fake. Government has therefore stopped there. Okay, there is an allegation. Let us verify. Verify it. Already other students are doing classes. Who will compensate him?
First round finish, second round finish.
So he in terms, if his certificate is held to be genuine, he is entitled for admission. Then who will compensate him?
And another
Call health department. We are not. This is a medical admission case. Yes, of time being. Yes, same. Next. We are not saying that his certificate is genuine, but who the institution or the organization or the college who has doubted it, they will have to come that, oh yes, this is a fake certificate. So his candidature is cancelled. Then he can come and challenge it. Yes, next case.
Item number 23.
That is same thing, I think.
23.
Item number?
That, in this case, the petitioner was promoted to the post of law.
Yes, yes, yes.
Subsequent after his promotion.
Now we understand what happened. Who is representing the department? BTC is having no role.
Elementary.
Mr. Sisti, here is a case. There is no dispute that they are entitled for promotion. Now they have been promoted, but Illa could have it. You have promoted them in the BTC area.
Yes.
Now it is said that you are having no power to post them in BTC, but they are counterparts or they are similarly situated persons who are also promoted with them and posted in non-BTC area. They are promoted. I think their promotion is interfered, suspended, and that suspension was rightly. A question may arise: why have you not come for vacation of that state? But question is that they also know that BTC is you are not having any power to appoint them in BTC area. So then file a stay vacating. Why a fresh representative? If you are saying that BTC having no power, file a stay vacating. So let us list. Okay. Heard Mr. Purkasta, learned counsel for the petitioner. Also heard Mr. Sisti and Madam for the Corolla Territorial Council. Full stop. Issue notice returnable on when the other method is fixed. No. Returnable after 4 weeks. Give a date. No private parties. Yeah. Okay. Okay. 19th of October. Mr. Sisti accepts notice on behalf of Loan and 3, and Madam, you accept in 2 and 4. As the parties are duly represented, no fresh notice be issued. However, extra copies will be furnished to the learned council for the parties. Let this matter be listed along with 8382 of 2022 on the next returnable date.
Item 59 of supplementary list.
Yes. Accountant come. Who has been appointed? Maybe they have not found good candidates. Is there any bar? Cancelling an earlier selection process and issuing an advertisement? No, understand. Tell us the law. You are having all requisite qualification. There is an advertisement. We'll have to know the reason. We'll issue the notice. Hard. Have you applied? No, when last date? 20. Okay, we'll say that you will apply, but your participation will not prejudice your right and grievances that has been raised in the present petition. You see that. Now, what is your prayer today? You want a stay of the advertisement. That not possible. Selection process staying in this background not possible. Or you want to take matter to be listed next Monday. Well, I am not inclined to pass any stay order. And I am sitting for 1 day. So if you want to have a chance, leave this matter on my. Where is Gogoi? I have seen Gogoi. Gogoi, come, Gogoi, come.
21.
Gogoi is otherwise busy, so Gogoi, no, see, similar issues may come on 18. Issue is this. You have called in for counseling, being the within the your select that list zone of consideration. He has come. He applied the certificate. In fact, he was counseling was almost over, but somebody files an app saying that his certificate is not fake. Now you decided, okay, it may be right also. Why should a person deprive genuine candidate? So you have sent it for verification. Do the verification at the earliest, then give a result.
Yes, the verification will be done
Whatsoever, you will have to send it.
The problem is they have to make the department party.
Oh my goodness. Why are you looking on these technicalities? We are in a read court.
Exactly, my lord. That is my problem. I don't represent the department.
Okay, you don't represent the department, forget about that. We'll call Advocate General. We are in a read court. Don't represent them, then take your seat. Take your seat, please. If you are not representing a party, take your seat.
But my department has been made a party. That is why I am here.
Don't say so. Your department is no role. Your department is having no role.
No.
Okay, take your seat. See, thing is like this. Why should they wait? If it's a fake, then we'll consider their certificate. This is not our business. It will go to whom? Or to you or to him. We know the health department because health department has decided to send it for verification. It is their responsibility to send to the proper authority. It is not his responsibility. He has not raised anything. According to him, his certificate is genuine. Why is he will go to him? This is the health department, health education, who doubts on the basis of some third party's complaint. And they are having right to do that. It's not that third party's complaints cannot be entertained. They are having a right to, and for that a committee is there. They will send it to proper committee. If not send, they will send it. They are not parties, therefore a student will throw him from this court. It's a simple issue. If he's not, show him the road that no, you are wrongly collected this certificate. This is you do not belong to Tree Tribe community. So this is your road to not to the Bhangagar, to the other side.
Ultimately, the endeavor is that go to the
Genuine candidate, that's all. For that, why should he come to the grid court? You do it earliest. Okay.
You have already been allocated, but
Not with it. That's why he's in an anxiety. And you know, medical examination. Students are committing suicide. So craze for this.
I also
See-
anxiety, your current counseling had already started. Or that should maybe
No, that they cannot do. And they will not do it. They will not do it. We have seen it medical to a extent we will have to appreciate. This system is till now is a foolproof. Till now it's foolproof. Until and unless your certificate is paid. Okay, Mr. Gogoi submits that he will obtain instruction whether the verification so far relating to the certificate of the present petitioner is sent to the Department of Social Justice and Empowerment, and if sent, whether any decision has been taken in this regard. in as much as the petitioner has already been allotted a seat after the counseling in NEET and EET capital within UG, NEET UG. However, such allotment is withheld for the reason that there is a complaint regarding the genuineness of his certificate of being a OBC. OBC within bracket T TZL. TZL.
And the extra copy of-
Extra copy, give extra.
And madam, name of the health department.
Okay, registry to list, show the, list this method showing name of Mr. D. Gogoi as standing council health department. That is the issue. Mr. Darwai, who is the, see, a student is before us who scored a number and got an appointment. Think of his anxiety. We are in read code.
That is what I have to correct the matter. my lord.
Yes.
If that department is.
That is not his business. That is not his business. That is the business of health department.
23 also same.
Huh?
Same, like the-
23, same.
20.
You have it. You get it done. If a genuine candidate, if he is genuine, let him go. And if he's not genuine, the other come in.
Yeah.
That's all.
I also, because the genuine candidate get-
Yes. কিমান আছে এনেকে? মোচন হে। Order same আছে। যদি নাই মানুহ তেতিয়া বিচাৰি যা। এখানে আহিছে এতিয়া অসম। Job teacher.
There is an order of this.
Yes, my lord, as per last order, here this is the instruction, and here as per our instruction, it is stated that the petitioner is the case of case joined as the second court as grade 4 at Dramata High School.
No, that we understand, but that question is you have to answer.
Yes, ma'am.
But answer, we will answer in a affidavit, on a affidavit, so that she can rebut it if you go against that.
It is already filed.
They do not know about the case, madam, because all the gate, second gate person, petitioner, approach before the honorable court and obtain order to regularize the service of the petitioner. Accordingly, this honorable court passed an order in the year 2003, and they have been regularized. But some of the candidates, they were not regularized. Again, they have sent the matter to the High Bar Committee. High Bar Committee rejected that. We are the holding the post of second gate court. And the similarly situated person have already been removed. That is the case. And now they have repeatedly stated that actually second gate court. That is not the case. madam.
As per provision of the act, also my lord, the second post is not available. Here also in the instruction also it is.
As per court order, we are regularized. Here is a court order.
Where is that?
By this honorable court, that is, madam, starts at 29. Is 29.
It is a high school, my lord.
Not high school, all school, elementary.
No, no.
High school is high school, but the urban is not only high school, elementary and as well as secondary.
Most confusing subject, this OBV for me. Page
Page 29 it starts, madam. On basis of that, madam, a committee was made, madam. High Bar committee, madam. It's page up to para 6.
now, according to them, hyper committee rejected your case.
Rejected, not rejected, madam. Later on rejected because the member of the High Bar committee was changed. They don't have any idea regarding all these things. madam. That is why they
Now,
rejected.
whether that hyper where is the rejection order?
That is, Rashid Ali Feruzi, page 55. Annexure A. The matter of Mohammad Mushin Ali of the High School, Rashid Ali. School, Buri Nagar, Nalbari workplace, before the committee, government dated 29/2/96 and dated, there is a provision for 1/4 of grade 4 in high school and one sanctioned post of grade 4 was allotted to the school at the time of domicile. The petitioner in this case is joined as second gate code. Therefore, as per norms, seasoning was recommended,
Not recommended.
recommended by HIPAA committee as a objection. But my lord, this honorable court has already been passed several orders, my lord, after rejecting the HIPAA committee lordship.
Where is the,
So
where
we
is the,
assume that similarly situated person has already been executed. But there is an order, I hope. I hope. Is there order, my lord?
no,
There's order only, nothing more than that.
are you aware of this order?
I have to,
Huh?
I have to go through it.
You do one thing. You file an affidavit, whatever you have stated.
Yes.
But in terms of this order, your statement, according to this, even two grade 4 employees are provincialized, in terms of this judgment. So you file an affidavit that what is the difference in this case and answer this. Okay. Pursuant to order dated 1/9/2023. Mr. U. Sir, Mr. U. Sharma, Learned Standing Council for the Secondary Education Department, submits that he has received the instruction in terms of the order dated 1/9/2023 from the Director of Secondary Education Assam. Accordingly, he prays that he may be granted a week's time to file an affidavit. Huh? 2 weeks? 2 weeks time to file an affidavit in this regard. Bringing on record the answer to the queries made by this court under its order dated 1/9/2023. MSK Devi, Learned Counsel for the petitioner, further submits that in a similar situation in WPC number 2801/2017, favorable order has been passed, and she prays that a similar order will retrace, if a similar order to that of the order dated in 19/11/2019 passed in WPC 2801/2007 shall cover her case. Mr. U. Sharma submits that he will go through the same and incorporate in the affidavit to be filed itself whether the case of the petitioner is covered by the decision rendered in WPC 2801/2017 within bracket Abu Bakr Siddiq within bracket Supra. Okay, give a copy to him. 10th.
Because 17th.
Yes, possible 10th.
Then October.
10th of.
Like,
The instruction is returned back to the learner.
I think 29 and 30.
This is a stop, just before you start anything, this is a stopgap arrangement, remind yourself.
It only takes 2 minutes.
Your 2 minutes I have learned many times.
Not the one thing.
Yes.
Like,
You want an adjournment?
not because.
Yes.
You will have.
We do not require the reason.
No,
No reason is required. You want an adjournment?
Only a small point, I don't know. why.
Oh, I know your small point. I have suffered a lot on your small points. There is a stay.
There is one. And UGC has clarified its point, Ahmedabad affidavit is clear and protected. Malad will fix it after next week, not immediate. On the
Verified, but also to some extent that they are, otherwise they are also clarifying that the what to be considered what to be considered.
My friend, and I am candidate.
Both are fighting.
Right, I'm my friend, I'll pick it.
And you are?
Don't worry.
He is the sufferer.
No, he is a sufferer.
Who is the principal now?
Nobody. In charge may be there. I
Who are
was
you?
recommended.
I am now representing
Department, you are department. And you are UGC. According to him, who should get?
We have clarified the issue.
No, tell us, Nayar or him?
No, she is not eligible.
Okay.
She does not have research guidance or research that supervisorship that was given to her, that was cancelled. So she is out. Yes, yes.
Okay, wait. A division bench judgment is coming.
Yes. Is that one is already cancelled? My lord, in that particular case, my affidavit is in detail, document go for this. Then only.
That DB, that is coming.
No, it is coming.
It is coming.
I sincerely request you both only. This will help, my lord. This will help this issue.
Okay.
But whatever is considered, he is not heading the vaccine.
It's heavy.
Vaccine is not be considered for anything. Isn't that case?
See, on adjournment, you all have spent more than 2 minutes.
5 minutes.
No, more than 5 minutes.
On Tuesday.
Okay.
I will be out of Thursday. What question do we come? On Tuesday.
When, tell us.
After 26.
After 26.
In the meantime, please have that.
27
Hmm?
27.
On 22.
Yes.
22?
Do alone,
UGC is required. He will return back on 26th only.
24th I'll back.
Back.
Then
So-
let it be on 26.
26th,
26.
26th.
That is what I said.
As agreed to by the learned council for the parties, please this matter on 26th.
In the meantime, I give it a very small point.
Huh?
Small point. All may be in vain after the division.
Hope that by that time small subjects should remain as small.
I think 33.
Yes.
I know the pursuant to earlier order of my lord, experience file additional affidavit, mentioning the report of the subject experiment. Let me.
What is the record? You can come up next week.
Okay, it is submitted. Who file affidavit?
I love Seba,
It is submitted the Learned Standing Council,
DK,
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 DK Roy for the Secondary Education Board of Assam.
the Board of Secondary.
Board of Secondary Education Assam has submitted that an additional affidavit has been filed by the board. However, same is not on record. Registry to place the same on record and list this matter.
Next week.
Many matters are fixed next week. The court will be
Long time not coming, but at my instance, again, I get.
so not thereafter on 28th.
28.
20th.
I think 34 and 35.
Yes.
And that your lordship will be pleased to see the order that is K5/2020.
KN 5.
K5/2023. Government advocates submit that they have received letters from different parents based on 12/5 for production. And there are some other 2 days of
Yes, paragraph 8 of the last order, 12/5/2023. You have received the record. So matter is ready.
Your lordship would be pleased to say, it is the type 2020. My learned friend submitting my note. He has received it here.
The final opportunity to complete the instruction and produce the relevant records in support of their contention as to which proposal containing the name of the teachers were received from the office of the Deputy Commissioner Dhubri was put up before the competent authority, and as to how under RTI a different document presently stated to be not available in the records of the Deputy Commissioner Dhubri has been furnished to the respondent number 7 and 8 in response to their application under RTI. This instruction be placed before this court, and then they please file an affidavit on that. Yes. Huh? No, record is there, but the explanation is short for. You'll have to file an affidavit in terms of paragraph 8. Is that it?
Your lordship would be pleased to see the order dated 2/5/2020. SLC report is also to be produced.
2/5.
2/5/2020. So 12/5/2020. Director Elementary Education.
That order I am saying. That order I am saying. Are you aware of this order? Not only SLC, you go through paragraph 8. Are you having this copy of this order? You have it. There will be serious ramification. There is a direction. And it is observed that it is the last opportunity. The Mr. Bora, Learned Standing Council for the Elementary Education Department submits that due to inadvertence, the direction issued under order dated 12/5/2023, more particularly in paragraph 8, has not been complied with, inasmuch as he may be granted 2 weeks' time to file affidavit and produce the record in terms of the order dated 12/5/2023, more particularly in terms of paragraph 8 of the said order dated 12/5/2023. Okay. Though it was provided in the aforesaid order that a last opportunity was given to do the needful, which is reflected in paragraph 8. However, on the persistence of Mr. Bora, the matter stands adjourned, giving him another opportunity. However, no further adjournment shall be made on this regard, and if necessary, the court may direct personal appearance of the person concerned with the record to be produced. Don't miss, because there are 2 reports. Yes, date. Bora, give a date. After 2 give a date. As per your convenience, so that you cannot blame. 4th of October. Yes. Same.
1936.
Affidavit in opposition.
The last occasion you will have to file an affidavit. You have sent it for signing and everything. Lordship, give us for which time you will be filing it.
Okay, it is submitted that in okay. It is submitted by the Learned Standing Council for the Elementary Education Department that the affidavit has already been prepared and has been sent for vetting, and the same could be filed within a period of week from today. Accordingly, a prayer for adjournment is made. Prayer is allowed. List this matter on after 2 weeks, give a date. In the meantime, after 5th of October 2023. However, the affidavit shall be filed within a period of 1 week, and thereafter the petitioner may file a response to the said affidavit before the next date fixed.
37.
Yes, 60 affidavit. Oh, 60.
Board of secondary, board of secondary education, we have no, both SSA and SSA and board of secondary.
What SSA, who is SSA?
I'm going to.
You need to file affidavit or no?
If the board of secondary education is this party, and the board of secondary education has set up the. And they are.
What is the issue, madam? What was the selection? The present application is filed assailing certain questions and certain answers in the answer key relating to the questions in TET examination, the result of which was declared on 28th of May 2021. Where is your affidavit explaining delay? Full stop. In the full stop. This court, under its order dated 6/10/2021, directed the petitioners to explain the delay in approaching this court as to why they could not approach immediately after the result were declared. And accordingly, notice was issued keeping the question of maintainability of the present writ petition open. Full stop. Mr. Bora, learned counsel for SSA, for respondent number 5, submits that the question papers were set and answer keys were prepared by the Board of Secondary Education Assam. Therefore, the Board of Secondary Education Assam shall be a necessary party. Full stop. In view of the aforesaid, the learned counsel for the petitioner submits that she may be allowed 2 weeks' time to file an affidavit giving the explanation in terms of order dated 6/10/2021 and to file an IA for implement of the Board of Secondary Education Assam as a party respondent in this case. Accordingly, such prayer stands allowed, least after 2 weeks, on a date to be fixed by registry. You will have to explain that is your maintainability is kept open.
38.
Yes, Mahmood.
My lord, in spite of being entitled to the provincial as my post was dropped due to wrongs sending the particulars from the district committee that has been admitted by the authority also. Lordship may kindly say, authority has recommended test 31 and 32.
But government, where is your affidavit, government? What sometime you are depriving a person, giving a last chance, giving a last chance.
The petitioner does not appear in the Ryan Journal up to 2011 to 2012.
No, we understand. Can your verbal submission on the instruction, a writ petition can be decided? Whatever the reason, you may have 100 good reasons. That you will have to bring on record so that he can rebut. No, these are not good reasons. I am entitled, so that we can take a determination. That's why. Let them file an affidavit, but you have taken. Okay. The present application is filed with a grievance that the services of the petitioner has not been provincialized.
Yes.
Provincialized,
So we can package only.
not provincialized due to wrong notion of the respondent, wrong notion of her appointment by the district scrutiny committee. Full stop. The learned standing council submits that she has received instruction. However, some time may be granted to her to file affidavit in opposition. Such prayer has also, such prayer were also made on more than 2 occasions. And the adjournment was granted. However, Mr. Mahmood has expressed serious urgency in this matter. Accordingly, it is provided that as the instruction has already been received, the affidavit be filed invariably within a period of 2 weeks from today. And list this matter thereafter on after 2 weeks, 3 weeks, on the 3rd we give a date. 10th of October 2023. The affidavit be invariably filed within 2 weeks, and thereafter the petitioner may respond to such affidavit prior to the next date fixed, if so advised.
39.
You need an adjournment. Okay. On the prayer of the learned counsel for the respondent petitioner, the matter stands adjourned and be listed after 2 weeks.
Thank you.
Yes.
40 and 41.
Yes. Hmm.
I am without any pay minor from the 1st of April 2022. And there file an affidavit, my lord, that is stated that the interim order was passed without consulting the higher department.
I think we're 40 or
You are a professor.
I am the first principal of Durham Engineering College, my lord. I was promoted to the post of professor, my lord, on 30/2022 under Career Advancement Scheme. And my lord, since I was promoted to the
You claim to be 65.
65. There is a notification government to that effect.
So what is the stand of the government in affidavit?
My lord, in this affidavit, my lord, the government stated that they have received their finance conference on 21/2023. And now, my lord, they are going to again revise the recommendation made by the DPC.
Have I taken up this matter earlier somehow?
The second petition, my lord, has passed the interim order. Second petition was filed challenging the.
I recall somewhere
They have also replaced me when another advocate. Second petition was.
Now what to do today?
From 1/4/2022. And I admitted that this order was passed without consulting them.
To decide it, if he is without, okay, it is submitted that Mr. We'll see all this later on. You keep it. Let Mr. Gogoi come and we'll decide this matter. Then all this will come. Give a copy. It is submitted that Mr. K. Gogoi, Learned Standing Council for the Higher Education Department, is having some difficulty today. Accordingly, a prayer on his behalf, a prayer for adjournment on his behalf is made. Same is allowed. However, the Learned Council for the petitioner submits that the petitioner is without salary with effect from 1/4/2022, and therefore there is urgency for him in this matter. In view of such contentions raised by the learned counsel for the petitioner, while adjourning the matter, this court fixes the matter for considering the aforesaid prayer, let this matter be taken up on 4th of October 2020.
Item number 42.
Yes.
Yesterday from the ISCC, the picture was taking the witness again.
Okay.
Today morning.
Okay. It is, we adjourn it. Let us see on the prayer of the learned counsel for the petitioner, let us stands adjourn and be listed after 4 weeks. The learned counsel submits that the petitioner has been called by from the office of the inspectors of school and asked her to submit her particulars. Accordingly, he or she accordingly, she has submitted the said documents today morning itself. So as the matter seems to be under process, the same stands adjourned for 6 weeks and be listed after 6 weeks on a date to be released. You make a mention if something happens, it may become impracticable. Let us see.
43.
Yes, Mr. Mahanta.
Is applied to the additional affidavit submitted by that.
Hmm.
Has been filed today, not from the court.
Okay,
So, nothing to pick up any other day.
okay.
We have some urgency in this.
Yes.
So what is the issue here?
Regarding the.
I did say in the appointment letter of the.
Oh, this is KK Hindi.
Yes, taken.
Should I take up? I was just standing counsel. Next week, list this matter next week. In the meantime, the affidavit filed by the petitioner be tagged with the record. Interim order shall continue till.
45 and 46.
Here, this is the issue relating to the appointment to the post of principal of the government law college. Sorry, university law college. University law college. There are two restrictions filed. Right. First, this petition relating that WPC 4111 of the what these are ready for hearing, my lord. So, and which because they have a because the community design.
Today is a stopgap arrangement. Bench is a stopgap. Only for today.
I have also in such a position that my retirement is only for 5.4 billion. That is why there was an article which is recorded. That
Last week of October. Tuesday or Thursday.
You are for? You are the principal now.
and now.
You are challenging her appointment.
No, not exactly, yeah. There were 2-3 changes made meanwhile, ultimately.
Okay.
I said that it is one additional.
The affidavit filed are on record or are on record. And matter is ready for disposal. Accordingly, the learned counsel for the party submits that matter may be taken up on
October first week.
even if
Or before that,
you agree, because there is a problem. Mr. Samwa is
In the outdoor station.
session.
On October 5 million Thursday.
No. His presence is required. We require his presence and to record his name. Rest forget. 6th of October, Mr. Mahanta. Fifth. Okay. Give a date, Kumdo. I have no problem giving a date.
Maybe on the 2, 5, 6. Yes, 6.
Six. Someone is here. No, he will be out of station. That's why.
For a week.
For a week. He's returning on 26th, I
I
think.
know.
20. No, he's returning on 24th.
26, my finger cannot. I will have other.
So that on 4, not 6. It is item.
Sixth.
Sixth. Item 47.
Yes.
Page 37.
Yes, affidavit, department.
There is no application is required. Page 27 is indicated. What it says that the areas are application, there is a particular location. So only because you don't have a court order, you cannot release the area. The second paragraph. The one has to come with the court's order, go to the court first and then get something which you are entitled. That will be stand here.
That is conditional. You may get if something remains.
That is unfortunate in fact, Lordship, the earlier order of the honorable court was 2016, 15 years, that was 824. The issues are already decided. Back in 2015, 8 years now. Now they come up with the plea that I have to approach the court first, there is an order. And something remains, I'm entitled to the something remaining only on by due to the court's order, not by my entitled to that form. The second round application is also page 24. 26, your option is the operational part.
Yes, what is the instruction? How can that be? This is, are you getting the current salary?
Yes, that is.
Page 37. That allocation has been with respect to financial year 2022-23.
All the more reason from.
No, I'm not saying that. Pointing out.
The present petition relates to non-payment of arrear salary to the petitioner with effect from
1997.
any date?
Yes, 1997. You got it. 31/10/1997
31/10/1997 to
and 31/10/2002 with respect to selection base scale. The two different scales.
from third, first tell us 30,
31/10/1997.
the two
30/10/2002.
30/10/2002,
Yes, there are.
30 to 2002.
Yes.
The petitioner earlier approached this court, and this court in WPC 1910/2030 under its order dated 25/2015 directed the respondent authorities to consider the claim of the petitioner for arrears of salary for the aforesaid period. Full stop. Referring to Annexure K, page 37, Mr. Sharma submits that the entitlement of the petitioner has already been admitted to be due, and a proposal was also made for such payment during the financial year 2023. However, till date, no such payment has been made, and in the meantime, the financial year is over, and she is suffering even after a favorable, even after existence of an favorable order passed by this court. The Learned Council for the Higher Education Department, though has taken time earlier to file affidavit in this matter. However, no affidavit has been filed. Full stop. From the Annexer K37, it is seen that the Director of Higher Education has made a proposal to the Commissioner and Secretary to the Government of Assam, admitting the entitlement of the petitioner for the arrears of salary claim, and also made a proposal how her grievance can be redressed by payment. Full stop. In view of the aforesaid, the Learned Standing Council for the Education Department shall obtain instruction and apprise this court how and in what manner they are and within what period they are proposing to release and pay the arrears salaries to the petitioner on the next date fixed. Such instruction may be brought either by an affidavit or by an instruction from the Commissioner and Secretary to the Government of Assam Higher Education Department. Full stop. List this matter on. Give a date. Mosumi,
11th of October.
11th of October.
48.
Yes, Mr. Sheikh.
Here in this case, the principal of the high school, retired one, has said a student, retired.
Hmm.
I'm entitled to get the. I'm entitled to get the inserts of that school. That is not given. Your lordship will come to pay 70. Earlier occasion also I came before your lordship. And your lordship.
Yes, Standing Council, there was a query.
My lord, in this matter,
You will have to inform this court as to why only limited entitlement is given.
Yes, my lord. Earlier, my lord, Anjana Soikia Bora, MABA, was the insert principal insert of the school and with financial power.
Hmm.
Thereafter, my lord, due to interference of the honorable court and Siddiq Anwar, Anwar was given to start and on only, my lord, academic affairs, deal with the academic affairs and his knowledge with this man. So as per my instruction, this is.
No, the court is, we do not know. Court is asking Mr. R. Mozumdar appear. Learned Council for Secondary Education Department of Government of Assam to inform the court as to why only limited entitlement is given. Here a case is this. The Learned Council for the petitioner submits that after the interim order of stay against the respondent number 6, the writ petitioner has been made the in-charge principal of the school, but was given only the academic charges, not other charges. Therefore, the Secondary Education Department to inform this court as to why only limited entitlement is given. That will have to answer.
Another, because in this instruction, this part.
This is specific. The Mr. U. Sharma, Learned Standing Council for the department. What department? Secondary Education Department submits that he will obtain the specific instruction as directed to be obtained by this court under its order dated 1/9/2023 on the next date fixed. Inasmuch as due to inadvertence, she did not sought for such instruction. Full stop. Accordingly, the matter is be listed on when. Why you needed 2 weeks? That's the reason you can have in a telephonic instruction. 10 days. Give a date after 10 days.
Your lordship,
In this
Just
very
that-
simple matter, my lord, it may be the last chance for that. They will take
Okay.
instruction.
ten
Somebody will
minutes.
appear before your lordship. He will
No.
forget, he will not come. Another
No,
comes, they will
because-
come. In this way, my lord.
On list on so and so, so and so. And on the said date, 29/9/2023, and on the said date, the instruction as sought for by this court under its order dated 1/9/2023 shall invariably be produced. Otherwise, this court may order personal appearance of the competent person.
My lord, it may be, it is, difficulty, my lord, my reviewer.
Hmm.
Is, has some.
Yes, give a date, give a date.
October first week, ma'am.
Give a first date,
Third
3rd of October.
49 and 50.
Yes, Mr. Doctor. Okay, it is submitted by Mr. Bora that he may be granted some time to file affidavit. So the prayer is allowed. This matter after 3 weeks. In the meantime, the parties may exchange their pleadings.
For orders, item number 51.
You say that it's under consideration. On last occasion, it is.
In the meantime, has to be purchased from trade inspector, my lord. I have to incorporate all this, my lord.
Okay, Mr. Bora submits that he has received some press instruction. Accordingly, wants to file an affidavit incorporating the entire instruction. Accordingly, he prays for an adjournment. Full stop. Prayer is allowed. Is this matter after 2 weeks, by which date the affidavit be filed?
52.
Yes, Mr. Saikia. Yes, pension. Who is the authority? Who is the order? Yes. First time listed on what? Page? Just a minute. Page 13. Paragraph 7. Notice served upon the condemner.
Yes.
Who is representing? Who is the operative person? Page. Page 13. Just a minute. Okay, so areas of salary.
The review, what was input on that? Review order was in finance case 15. And the relevant person finance case 24.
Call Mr. Fukon. Review dismiss or what?
Amount of cost of
Where is that cost? Page?
Phase 25.
Yes, you are in difficulty today. Who is this officer? Yes. Madam. By two, deposit 50,000 in his account. This is not done. This is not done. Who is this officer? Who is to do this?
So that already, our schooling has been about in the high school.
Forget about. There was a direction for payment of area salary, not even consideration. Your decision was set aside, specific date was given from this period to this period, pay salary. You file a review dismissed with a cost of 50,000. First 50,000 deposited, come at 2 or bring your commissioner at 2. Who will do this? Who is the contemner?
You committed earlier.
Oh, forget about, your standing council is there? Okay. Now who is new commissioner?
Narayan Puramal.
You have an instruction, telephonic instruction. Give these 2 orders and tell us by which date you will pay his arrear salary as well as the cost. No 2 days time. Huh? Oh, forget about evening limit. This is a case of contempt. Who is suffering from cancer? Vijay Sutri is suffering from cancer. Let him get treatment. That is not our issue.
That's why I'm saying, 2 days time.
You have an instruction from the, we'll adjourn it. You have an instruction from the commissioner, give this 2 order of these 2 copies, download from the website or whatsoever, we do not know, and come back to us after 15 minutes. At 2. We'll sit for you only at 2.
53.
How we are proposing to do? Yes, Sharma. Where is the order? Okay. This is an application under so and so. Issue notice returnable in 4 weeks. Service both ways.
55.
In addition, petition is permitted to take the decision. Through the.
Order is made.
55.
And relevant portion is paragraph 33 gets to decision.
Page 15.
And relevant paragraph is also very just 33. Order is not so good. Now when the petitioner is so good, we submitted evidence that no acknowledgement. Paragraph 33.
Paragraph 33. Yes, higher education. Okay, we are issuing a notice. I'm not sitting regularly, otherwise I would have asked him to bring the instruction. You would have gotten the fees. Notice. You have the instruction by next day and appear. We are issuing notice.
Order is so good.
4 to it.
But they are not compliant. Even outside state of.
He is under treatment. This person, no?
No, we are also Mr. Gabata.
Okay.
We are not appointed. We have to this one director appoint support to it. The application I have.
No appeal file. Then it has a 10 final.
That's one of the notification has been set aside.
Okay. Issue notice. This is an application. Journal order. Application assailing violation of order at so and so, so and so. Here is the same. Issue notice returnable on 9th of October. Full stop. Stays within 5 days.
56.
Same.
57.
Yes, Mr. Sheikh, what is this?
My case is very simple. My high school,
Hmm.
the petitioner before the lordship.
What is the IA?
IA is not relevant now.
If IA is not relevant, we'll fix the matter in admission. IA, can we close the IA? Okay. Mr. Who has filed? You have filed this IA. Mr. Sheikh submits that the IA, he is not pressing the IA. Accordingly, same closed, being not pressed. Now, WPC 4380. And which IA? We have closed this IA 2598. Both the IAs, huh? Okay, both the IAs are disposed of on not being pressed. Now, what is the main issue?
Main issue is the election. High school established in the master. There is a
Amalgamation.
every master.
Okay.
Every madrasa is existing now.
Hmm.
But after provincialization of service of some people,
Hmm.
some teachers of this high school,
Hmm.
that this school was amalgamated
Hmm.
2 kilometers away from the campus.
Okay.
Our grievance is this. There is provincialized every madrasa.
Hmm.
So this school may be on that particular location.
They have constituted a committee for reconsideration and what we call it. They have used a beautiful word. Redetermination and reconsideration of the grievances, like you. An appellate committee has been constituted. We are sending you there. If raise your all these grievances and come back to us if you are agreed. Huh?
So it can be done.
Okay. An order was passed, the dictation was taken. Which item? Item 2 or 3 we have disposed of. Huh? Item 3. Now, amalgamation is huh? Item 13, no? Mr. Bothakur was there as item 13, no? And is your school being already amalgamated?
Yes, madam, that order is there. In
So
2020.
in actual, has it been done?
Yes, actually,
Okay,
actually it is done.
okay. So within 4 weeks, they will dispose it of. You file a fresh representation before that committee. They have constituted an appellate committee so that they can look into all the grievances. Okay. Then you approach that jurisdiction and dispose of.
Online, keep it free.
Definitely, that already also in desk with us. They will be at liberty to approach once against this court, a line to litigation. The petitioners shall be at liberty to approach the appropriate forum in case their grievances are rejected by the appellate authority.
Decided by within 4 weeks.
4 weeks from the date of receipt of your representation. Dispose of.
58.
Yes. Okay. Affidavit, you have to file
In the
affidavit.
meantime,
Okay. Mr. Dekha, learned counsel for the respondent number 5 submits that he may be allowed some time to file affidavit. Full stop. Prayer is allowed. Accordingly, list this matter
26th of September.
on 26th of September 2023. In the meantime, interim order pass earlier shall continue. Yet, what is the other aspect? File an application. We'll get a hold of them.
Already the inspector is allowed to.
Okay, so all this disputed, let him You also explain that so that,
also. Both the parties are not eligible.
okay,
That is why instructor is allowed to stand.
okay,
But in the meantime, yes, they were.
okay.
I'm busy now.
Supplementary item 60.
Prakash, sir, you are here also.
Now, if the content is so, of the family, any plan,
Case 9. Case, what is the direction?
Matter is just from a note, medical admission. We approve the authority matter as made a representation, when the application to issue in non-criminal setting. That was not done, ultimately, application of report, ultimately, matter is received or disposed of, directing the, respondent to take a decision within 2 days. Counseling is going on, matter,
Yes, yes, yes. Which department?
medical.
Medical, call Mr. Gogoi. Call Mr. Gogoi, we'll have it today itself at 2. There are 2 matters only. 2 matters there. We could have finished it up. Gogoi is a very busy lawyer. Who will issue the criminal certificate? Deputy Commissioner. Yes, you have an instruction at put. If he's in criminal, he's criminal. If not, he's not. Kindly see, Mr. Prakash, show him the order. Because it's very urgent. That's why. Suppose he is having the criminal, he might get an admission. If he's not, then he's not.
Last round of counseling is going on, it is over 70.
That's why.
And the counseling matter, against his report was so fixed, matter, that-
Yes, paragraph 3 you see. Okay. Come back at 2. You have the instruction and ask Deputy Commissioner to do needful, whether it is, what is the procedure is there, because maybe it will become infractious. Then we'll put this man to jail for non-compliance. That will have nobody. At 2. Okay.
And moreover, okay, at the direction in the, 16 that petitioner was supposed to furnish the bank details. So let the petitioner submit before the respondent, okay?
But still, still, okay. Mr. SMT 16 submits that the new director,
The secretary.
that the Secretary Education has very recently joined, and the earlier secretary, who is a respondent number 1 in this present petition, is having some serious ailment. Full stop. In that view of the matter, Mr. 60 submits that the amount of cost can be transferred to the account of the petitioner within a period of 2 weeks. 2 weeks after the submission of bank details of the petitioner as directed by this court and before the secretary. District order. Accordingly, Mr. ISIK Learned Counsel submits that within a period of 1 week, he will submit the bank details before the present secretary, and thereafter the cost as directed shall be full stop. Accordingly, the cost as directed shall be deposited within a period of 2 weeks thereafter. Full stop. So far relating to the payment of arrears salary, there was a specific direction to pay the same, and accordingly, Mr. 60 submits that the said order shall also be complied with and has not been complied with in as much as the new and incumbent has already started the process. We have recorded that. And accordingly, Mr. 60 prays that matter will be listed after 4 weeks. After 4 weeks, no. After 4 weeks. In the meantime, the order passed by this court shall be complied with. Arrear salary. It is arrear salary. You'll get it. unnecessary if you give, because they will have finance correction, this, those things are there, we know that. We may pass an order, but we'll fix a date after 4 is given it. You look into it, because it's not a, not a case of any consideration, specific, and review dismissed. Yes.
60.
No communication from?
From the petitioner regarding this order.
Any
Particular order, I have already WhatsApp in this page number 13, along with this figure number 3.
Where is your communication?
September 13.
Huh?
2nd September 2015.
Where is your receipt? Where is your receipt? Where is the acknowledgement?
According to us,
Then we'll have to believe them only.
we are making a statement from March.
No, I understand, but he said that they have not received. And that we'll believe, because there is no endorsement. Anyway, don't argue beyond that. We are concerned with the student. So what do you do? Just a minute. Yes. Okay. It is comma. 5.
We have stand and email communication. I have already both paragraph 3 in this particular.
See, Mr. Purkasta, certain cases it's a contempt. Otherwise, what we can do? We can issue a notice. We can issue a notice, and if he has violated, we can put him behind bar. But we are going out of the way, and the learned council also assisted properly looking at the situation, emergent situation. Because our intention is not to put the deputy commissioner inside jail. Our intention is that the order is complied with. An order is such an order that if it is not complied with within a specific period, whole thing will become infructuous. So therefore, even without being authorized, he has taken instruction. You should be grateful to him, not to this court, to him. Yes. So he has taken that instruction, says we will take 3 working days. Can we say no, we'll have to do right now? Okay. The present contempt application is filed alleging violation of order dated willful violation of order dated 30/8/2023 passed by this court in WPC 4510/2023. The operative portion of the order is quoted here in below. Full stop. In view of the emergent nature of the order, inasmuch as the involvement of admission of a student into medical course, instead of issuing a notice, this court requested Mr. So-and-so learned counsel, government counsel, to obtain instruction why the order has not been complied with. Accordingly, the learned counsel has obtained instruction from the concerned district, from the additional deputy commissioner of the concerned district, as the deputy commissioner is out of station, And on instruction, he submits that, in fact, the order has not been communicated to the department, to the deputy commissioner, and deputy commissioner is not aware of such order. Be that as it may, as the matter, however, the learned council further submits on instruction that the necessary action can be taken in terms of order, paragraph 3 of the order within a period of 3 days from today. In view of such submission on instruction, the matter stands adjourned and be listed on next fourth day.
Around 19th and around 21 and.
Next fourth day, কোন দিন হবো?
So, looking at the figure of 19th,
After 4 days, what is the date?
what day is 19th?
19th. On 19th of he's registered to list the name, showing the name of Mr. Saikia as seeing the name of Mr. Saikia. This court appreciates while parting with the record. This court appreciates the effort of Mr. Saikia in assisting this court. Mr. List this matter on 19th.
I am also activating my telephone.
19th. You just have a talk, because whatever way they do, as part of the order, let them do it. The only thing is that for non-compliance, he should not miss the seat. If he's a criminal, he's a criminal. If not, he's not. Court is not directed that to issue in a specific way. It is your call. Okay. Okay. Give a copy of this order so that he can forward it. And ask your client to go and submit a copy.
He has submitted the office of the deputy commissioner, and my learned friend has got instruction from the office of the ADC.
No, because deputy commissioner is not present.
He's not at the South Africa.
South Africa.
Just talk with him.
That it is why.
There is my deputy commissioner office.
That is the problem. Problem is that the peon or the receipt who has received, he might have kept it somewhere. We cannot always blame the officers in that way. We know the red tape is it, but still this is urgent. Therefore, even in a contempt, we requested he has done his job. That much we can do, not beyond that. Otherwise, in a contempt, we'll have to issue notice if we are satisfied. Looking at the urgency of the nature of urgency, we have done. Yes. Yes. Okay. See, he has taken the impulse. Okay, next case. There are some cases which we thought it was adjourned and something like that. Yes, well, what is that?
My junior was related. He should be able to say that when the matter will be taken at the stage at the end of March.
So he said, then somebody said, no, nowadays contempts are listed in orders. So we said that we'll take up along with orders. So there's a misunderstanding. So where is the order? Order 30. Just a minute. Which is paragraph 12? Where is that service of this?
In the case, I was a respondent and particularly the order of mail was also sent to appending my mail is up. And there are some letters article of fact. These are the TV letters,
Yes, okay. I'm not getting it. Who was the respondent number?
Just number six, I was, the issue was hearing because he was the number six.
Alauddin Sheikh. What was his grievance?
He challenged by the in charge headmaster of the district.
Hmm.
And that was state, but no order was directed to holding the charge of manipulation.
Hmm.
And the matter was, it was 8,000
Hmm.
and the matter will be considered a trade.
But this, you'll have to challenge this order. Still, you have challenged this order. I do not think there is a contempt. There is a stay. There is a stay.
He's not 8,000, 8,000.
No. You're holding the charge state. Okay. You're holding the charge state. That is, according to you, that will not mean that he has been allowed to hold. That is your case.
And
So they have committed a mistake that you have already filed a writ petition. So how contempt is there?
because whether it is the case or before, yeah, and please disclose of the risk.
Where is,
Last sentence,
that's why till disposal of the writ petition, you will have to challenge this, that this was the not intent of this order.
I have challenged it.
You have challenged it. So when that matter is listed?
Whether it is disclosed of the 31A.
31,
No, sorry, representing the 28
28, and list this matter along with WPC. Along with WPC 3368 oblique 23 on 28/9/2023. On the payroll. Christy, over. No part two. Nobody is interested in part two.